But in those days, he was considered to be a personification of ultimate knowledge, considered to be Kevalamurti. And then he was capable of clarifying the doubts, even sitting silently. Mauna Vyakhya Prakatita. Shishyastu Chinna Samsayaha. That was the observation made in Dakshinamurti Sloka. He is considered to be Parabrahman because even above the Trimurtis, Guru Brahma, Guru Vishnu, Guru Deva, Maheshwara, regularly we recite whenever there is Teachers' Day. But above that there is Parabrahma. He is equated with Parabrahma because he is the person who shows the path to reach the ultimate truth, my dear friends. We also know that how Ram, born as a human being, he never claimed during his incarnation that he was God, my dear friends. His personality was developed not only by Vasisht, even by Vishwamitra, Agastya, and a number of other rishis during Aranyakanda. One should remember the role played by these people, my dear friends. Guru and Shishya were never considered to be superior and inferior. They are considered to be partners in the process of learning. Those teachers must have told you that Sahanavatu, Sahanav Gunattu, Sahaviryam Karavavahi, all these slokas, Shanti Mantra, that is not rather praying one particular God. They pray in general the God to extra energize them in the process of learning. It is not about particular God, my dear friends. And then a teacher affects in eternity, and we can never tell where the influence stops. If you look back, this was the observation, of course, made by Henry Adams in 19th century. You look back, still you have the influence of your elementary school teachers. That is why Bertrand Russell has mentioned teachers are more than any other class, the guardians of civilization. Kothari Commission has mentioned the destiny of any nation is shaped in the classrooms. It is a fact, my dear friends. One should remember that the seeds of the Second World War were sown in the classrooms of Germany by the teachers who were admirers of Adolf Hitler. This is a fact. Teachers truly shape the future of our children. Therefore, the teachers themselves are considered to be the future of our nation. Even our new education policy says. My dear friends, for that, to achieve that great height, teacher should always be a lighted candle in himself. If he is not a lighted candle, he cannot lit the other candles. That is why the credo of any teacher is considered to be three things. Three irreducible minimum things, my dear friends. Update, upgrade, and enrich. This is the credo of the teachers. Update, upgrade, and enrich. As we know very well, William Arthur Ward, what he stated, the mediocre teacher tells, the good teacher explains, the superior teacher demonstrates, and a great teacher inspires. I should say, a number of times I have come to CMR University, especially with reference to teaching research methodology. My first slide was that. My guide was my Mori. I may not be which album. You must have read that book, Tuesdays with Mori. It is unfortunate that I lost recently my guide, philosopher, who shaped me into a human being, Professor C.K. N. Raja. The simple thing that to see whether you are a good teacher or not is that estimate the entry behavior of the students when they enter into the class, how much knowledge they have. Estimate is a terminal behavior. After the course is over or after the class is over, in the last minute, you evaluate. There are different ways of doing it. Terminal behavior minus entry behavior is the benefit accrued. If the benefit accrued is 0, you are not a teacher at all. If the benefit accrued is something, you are a good teacher. So, terminal behavior minus entry behavior is equal to benefit accrued. This is the formula of a good teacher, my dear friends. One should understand that teaching is always has a purpose. It is inspiring interpersonal activity of learning. Teacher is a facilitator of learning. He is a diagnostician of the student's needs. He is a motivating force. And he is not mere attention seeker. He is motivating. Motivation is different from attention, my dear friends. That you must understand. He is also an analyst of the behavior of the students. Unless you analyze that, you cannot meet the demands of the students. Of course, if you want to have good teaching experience, like good writing, it requires certain careful selection of the methods of teaching, tactics of the teaching, and strategy of the teaching, what to teach, what not to teach, all these things. But in every classroom, when you enter, 3 types of students you will see. Number 1, mastery-oriented students. There is no problem with regard to them. Even if you are very busy, even if you are otherwise, he starts nagging, he wanted to extract information, he will be roaming around, he will go to the library, and now internet sources, all these things, they are mastery-oriented students. Few students we will see in every classroom. There is no danger with regard to them. There is another group of students, they are failure-avoiding students. These people confine themselves to guides and other things. They want to somehow pass the examination, that's all right. They wanted to avoid failure. And they also preaches the merits and scholarship are irrelevant. Once you enter into profession, what we require is the degree. So we will pass somehow or other. There are other people, failure accepting students. In those days, my dear friends, very good teachers were there. We were asked to read Dias jurisprudence, pattern jurisprudence, like that. Some of the students used to say, we will not pass March examination, we will appear for September. These are all people who accept failure. These are more dangerous to the classroom because these failure accepting students infest failure avoiding students and make them as failure accepting students. They may not be able to spoil mastery-oriented students. So the role of the teacher is that to see that everybody will be mastery-oriented students, or at least failure-avoiding students. We want, as teachers, everybody should be experts, so that we will have that happiness tomorrow when they say that we were students of so and so. We feel very happy. My dear friends, with this brief introduction, a general background, let us enter into the field of constitutional law. Teaching constitutional law is the topic allotted to me. For a few minutes, I have taken time to explain the importance of the teachers and classroom composition. It is a separate class by itself, teaching techniques in general. Now, not all will get opportunity to teach constitutional law. We were 7 students, classmates. We were all selected in a particular college. But only 2 people got the opportunity to teach constitutional law. Even though our specialization was constitutional law. Not all will get opportunity to teach constitutional law. If you get the opportunity, it is an exciting one, challenging experience. It is not like settled law. It would be an intellectual feast. A lay person will become a legal expert. My dear friends, when you come to Indian Constitution, you will see that it has stood the test of the times for 73 years of its existence. It faced many challenges. It faced many onslaughts. It has faced several attempts to subvert it. It has many phases in its development. It has facilitated initially mixed economy, and then it went to socialist economy. From socialist economy, we came back again into industrial economy. And then we have also seen globalization. All these things are facilitated by the Constitution. You can have a number of cases. Balco's case, is it not facilitating globalization? And then, in accordance with the changing times, new rights were evolved by bringing the doctrines of transformative constitutionalism, or even though it may not be totally justified, bringing in social morality that is meant for something else. Okay, new rights were evolved, and then it has met the exigencies of or problems of pandemic, even though belated. It was criticized that the remedies were belated during COVID period, even to attend emergency cases. Constitution is not the same as it were in the year 1950. It was subject to 105 amendments so far at the rate of 1.5 amendments per year. It is an easy task to teach that subject. Large bulk of judicial interpretations over dark matter. This expression was used by Chalameshwar in Privacy's case. Our constitutional silences, D.Y. Chandrachud has used this expression, are marked with initially with literal interpretation, whom we call originalists, then intention seekers, and ultimately to purposive interpretation. There lies Afterwards, contextual, consequential pragmatism in their approach. So we have also labeled the judgments: activist, dynamic, and then judicial usurpation, judicial overreach. All these things we heard. We know where there is judicial overreach. We know where there is judicial activism and dynamism. There is a difference between judicial activism and dynamism, my dear friends. Keeping consensus with the society is judicial activism. Going ahead of societal needs to meet the future demands. If interpretation is made, we call it as judicial dynamism. Every part of the constitutional law has been subject to such interpretations. Starting from evolution of the basic structure, golden triangle, as I have told you, transformative constitutionalism, constitutional morality, and indirect discrimination, which has been evolved recently in 2021. The Indian Constitution, that is why Granville Austin, a wonderful book, small book, Indian Constitution, Cornerstone of a Nation. Indian Constitution is first and foremost a social document. The core commitment of social revolution lies in Part 3 and Part 4 of the Constitution. They are the conscience of the Constitution. They are included in the Constitution with a view and expectation that one day the tree of true liberty would bloom in India. That was the observation made by Granville Austin. My dear friends, two subjects are minimal for a teacher. Number one, jurisprudence. I am very weak in that. Number two, constitutional law. I cannot say I have mastery over constitutional law. It is difficult to say. But mind it, Constitution is a different subject from other subjects. It is closely associated with every subject. A person who is teaching the other subjects must have the gumption. He cannot ignore the field of constitutional law. Even the teachers of economics, sociology, engineering, artificial intelligence, ChatGPT, all these things, they have legal implications. Medicine, and even other subjects like newly developed subjects, you will have to have the grip over constitutional law. It requires appropriate level of teaching techniques. When you start teaching, what you teach at the level of LLB will be different from teaching at LLM level. Agreed? My dear friends, over a period of time, when we are teaching the constitutional law, we could arrive at 10 steps for successful teaching of constitutional law. Dashapadi, 10 steps. Number one, you will have to know, you will have to decide whether it is learner-centric or curriculum-centric approach. We will discuss on each point. Let us first note the 10 points. Number two, evolving suitable strategy and tactics of teaching. Not method of teaching. Now here We are not telling about that. Evolve suitable strategy and then method of teaching. Strategy, talent, and method of teaching. Set the objectives of the teaching. Set the objectives of the teaching is the third one. Fourth one, evaluate course content or evolve course content. That may not be possible for all. Evolve the course content or evaluate the course content. Then important one, assess the challenges one may face in dealing with the Constitution. Several challenges you will face. Sixth one, identify appropriate method of teaching. There we have noted strategy or tactics. Now we will have to identify, after noting the challenges and all these things, appropriate method of teaching. One important aspect. Seventh one, integrating ICT. Eighth component step is a review. Ninth step is decide on evaluation methods. These are all not teaching methods, evaluation methods. And then prepare a blueprint or instructional plan. At the age of 73, I may not require an instructional plan, but those who are in the beginning of the ladder of teaching, definitely they require. Nobody need to examine that. Nobody is there to inspect it. But you will have to have some instructional plan or blueprint for planning. Now, my dear friends, let us go to step one. Decide whether it is a learner-centric or curriculum-centric approach. If it is a learner-centric approach, teacher is only a facilitator. When teacher is only a facilitator, he will have to facilitate learning. The best method would be like Socratic method. Not, there is no classical Socratic method anywhere in the world. That is a misleading statement. It is modified. A variant of Socratic method is adopted even in America or in our country as well. Here, what you require is that students learning, we are facilitating. In the field of law, we feel comfortable only with regard to lecture method. That is a different issue. When it is a learning centric approach, your strategy should be different. But it may be available, my dear friends, in isolated islands of excellence like national law schools. You won't have that choice. Yours is curriculum centric. You will have to complete the syllabus, focus on teaching curriculum. You may not have that freedom to move out. Teacher determines what to teach and then what to deal with. And then when he comes to the semester end, he will be very speedy also to cover the curriculum. It is curriculum centric. Sometimes there will be teacher centric also. What is the teacher centric? Whatever teacher says, that would be taken into account. It is not the syllabus, it is not the headache of the students, nothing will be taken into account. Step 2, evolve strategy and goal. Goals are given in your curriculum, my dear friends. If it is a curriculum, don't interchangeably use the expressions syllabus and curriculum. Curriculum is not mere specification of items to be covered. It sets goals, even for each unit and subunit also. So, what are the goals to be achieved? And then, what is the strategy that we are going to adopt? When we are to achieve any objective by using a particular technique, it becomes a strategy. Tactics also is there. Strategy is based upon your goal. Tactics is the behavior of the teacher, which he manifests or she manifests in the classroom. No two teachers will be alike. Why? They are teaching the same subject, but your tactics will be different from other person's tactics. It varies from teacher to teacher. Teaching is an act of will, notwithstanding any specifications. Always the teacher will have an element of discretion. That is why no two teachers will be alike. Some teachers, they adopt the strategy or tactics in such a way, it is like taking grapes in the process of learning. My teachers are like that. Some teachers will have to peel the skin and eat like banana. And sometimes teachers will be like hard nut to crack. Even after completing my course, one particular teacher, he loved me very much, but I was not able to understand what he was teaching in the classroom. After reading Massey's book of administrative law, I was able to understand what is rule of law. He was telling roots, fruits, like that, but I was not able to understand anything. He was hard nut to crack like that. He is coconut type, but scholar, recognized scholar. So these are the strategies or tactics. Then objectives of teaching. The first thing is that when you are teaching constitutional law, the student must be able to identify what are the goals and values of the Constitution. Now we are going into the subject of Constitution. These are reflected in the preamble, my dear friends, wherein you have both instrumental values and goal values. Goal values are justice, liberty, equality, and fraternity. Instrumental values, how these goal values have to be achieved. When you are going to a railway station or airport, you will have different modes of your transport. We have adopted our transport, our instrument to achieve the goal values as sovereign, socialist, secular, democratic republic, and try to explain them by giving examples from various parts of the Constitution. In the beginning itself, the student must be given an idea of, exhaustively we may not be able to teach, that requires one particular trimester. What is Constitution? What is constitutional law? With examples. To that extent, even political science people will be teaching. Then, what is constitutionalism? What are the various aspects that control the government, limited government or government under control or limitations? Lord Acton, power corrupts, tends to corrupt, and absolute power corrupts absolutely, and we start from that. We will give quotations. But to understand what are those limitations, we'll have to give examples. And then when you are teaching that one, even though it may be a bit difficult, you may have to go for the classifications of constitutionalism. Our Supreme Court has adopted transformative constitutionalism from an African scholar. But there is another thing for liberal interpretation of the rights, living constitutionalism or positive constitutionalism. Babar's negative constitutionalism is also there. And then here you may just mention about the cases of Joseph Shine and Navtej Singh's cases. And then you will have to tell here only about constitutional morality. When you start telling about constitutional morality, several doubts will come, several clarifications are required. You can see in Sabarimalai case, both dissenting judge as well as majority judges, they have used the expression constitutional morality for their interpretation. What Grote has said, what Ambedkar has envisioned, very little discussion was there in the Constituent Assembly, was quite different. But Supreme Court has brought it. Then the third aspect of it is, we will have to give, even though briefly, about the constitutional background and framing of the Constitution. The questions may arise. Non-discriminatory clauses are there. Equality clause is there everywhere, in every constitution, including erstwhile USSR constitution. But why 15, 16, 17 and 18 articles they are mentioned? Restrictions on freedom. Why they have forgotten initially the word reasonable under Article 19 Clause 2, and subsequently by Constitution First Amendment Act they have modified the restrictions as well as they have inserted the word reasonable. So life and personal liberty again, with a rider of preventive detention, why they have brought it? What about the discussions of the Constituent Assembly debates? So it may not be possible to give entire thing. I am giving you only examples. Students must have grasp over black letter law, like black letter provisions. My dear friends, one suggestion: when you are carrying bare text of the Constitution, you call it as a bare text, not bare act. Acts are derived from the Constitution. So it is a bare text of the Constitution. So black letter provisions of the Constitution, first we will have to explain, and the decisions over that. How to apply these provisions to new fact patterns. There lies experiential learning, my dear friends. Moot courts and mock trials will give you the scope to apply the bare provisions to simulated circumstances or new pattern of facts. Let them see, get them to see the differences, hypothetical ones, no problem, my dear friends. And how seemingly minor changes, will give you different decisions. Those who are teaching constitutional law, I don't know. Those who must have read also, they must be knowing it. Minor changes have changed the decisions, my dear friends. Look at State of West Bengal versus Anwar Ali Sarkar. And immediately thereafter, Khati Rani Rawat's case. Similarly, Northern Caterers and Maganlal cases. Even though there is Fourth Amendment to the Constitution, why Vajrayar Munriyar case has given different opinion? And then how the principle of law of torts was brought into MC Mehta's case, Sriram Fertilizers case. We'll have to rather, these are the objectives to be exposed. Then, being a constitutional law teacher, additional responsibility is that you may have to tell about judicial craftsmanship. Each judge will have his own style. Very little. Not elaborately, you will not be able to tell. Suppose if you wanted to tell judicial craftsmanship of Justice D.Y. Chandrachud, he writes like a thesis. He's a wonderful professor like. But can you explain? With one or two cases, academic year will be over. Okay. Judicial craftsmanship, the travel between A.K. Gopalan to Maneka Gandhi and after, including the latest cases, and how right to equality, prohibition against discrimination, ultimately led to indirect discrimination doctrine in Lieutenant Colonel Natasha's case, teaching about judicial review, judicial activism, these are all part of it. One thing which we should tell the students, one LLM student, when we were asking a question, he was not able to make a distinction. What is the distinction between judicial power and judicial review? Judicial power, a part of it is judicial review. That must be clearly explained. The objectives may include the procedural settings. Constitution, as I was telling you, is a subject which has implications in history, political science, economics, critics of law such as policy orientations coming from human rights, gender perspective. So it requires rather a case analysis, my dear friends. You can give number of things. If you scan through the provisions of the Constitution, you will find, when you think about status of president, a discussion over President Shamsher Singh's case. Tomorrow you will be listening to my learned colleague Vijay Kumar, who will be talking about conventions. He always used to say, ours is not parliamentary system, it is only a classical presidential system, something like that he will be saying. We deferred, we used to go for cooperative teaching. We have our own opinion, our own support. I based my argument on concurrent opinion of Justice V.R. Krishna here in Shamsher Singh's case. When you talk about federative principles, GST, is it not coming under economics? Human rights perspective, as I have told you, Article 13, Clause 3, when it prohibits custom or usage, law is explained. What is law? Even though statute is not mentioned in the list. Under Article 13, Clause 3, specifically they have stated what is law. That includes even custom or usage. So discussions may go on, even Article 253 and all these things. In the objectives of imparting constitutional law, plurality of opinions also is very important. What is concurrent opinion? What is dissenting opinion? All dissenting opinions are not unimportant. some of the dissenting opinions have become present day majority opinions. Every day you can see constitutional developments in the newspapers. So it is our duty to tell about latest cases, including, of course, even governor's power and all these things, and importance of judicial verdicts, how binding they are under Article 141 or Article 142. You may have to explain. Case comment is always necessary. At least one case comment let each student write. Constitutional law, no doubt, can be taught as doctrinal course, but it requires more than that. When you are discussing controversial things, you are discussing about UCC, you are discussing about governor's powers, you are discussing about entry into Sabarimala temple. There are certain things on which the society itself is divided. As a teacher, mind it. You can have as a person your opinion. But in the classroom setup, what I suggest is that there should be a value neutrality. You can have discussion, but your responsibility is to show value neutrality in the cases, and then there is additional responsibility on us when we teach Indian constitutional law, because many of the provisions are taken from other constitutions, analogous provisions, new approaches. These things we may have to discuss. Step 4, my dear friends, we have traveled up to step 4. If I am exceeding my time, let the anchor stop me, I will stop. Okay, otherwise I will be going on. Step 4, evolve and evaluate course content. Why you will have to evolve and evaluate course content? You will have to opt for appropriate pedagogy. Pedagogy is a word when we were students, everybody was using, teachers, we were not able to understand what it is. It is theory and practice of education, simply to tell, in any discipline. So that pedagogy, how to develop in order to teach effectively, for that you will have to evaluate the course content. I have told you the difference between curriculum and syllabus. Remember, constitutional developments are always in flux. Constant update is required, even with regard to curriculum and syllabus. Not once in 3 years. Every 6 months it has to be updated. At least for us, every year it has to be updated. When syllabus is framed in 2020 and revised in 2023, what happened to indirect discrimination doctrine? What happened to constitutional morality doctrine? All these things, my dear friends, it requires constant update of the curriculum. That is a must. Most of the teachers, of course, they do not have necessary autonomy to tamper with the curriculum. But when you are adding to it, you can have your own private curriculum. You can add to it. You can tell the latest position always. In their wisdom, teachers can correlate certain new developments to the existing curriculum, my dear friends. Assess the challenges, next one. The 5th one is, you will have to assess the challenges. My dear friends, I tell you, every subject has its own techniques. Constitutional law has these things. There is no constitutional law without politics. Every day happening. Everyday happenings are manifested. Comments come. When comments come, then you will have to answer in the class. You cannot escape. You can tell, of course, we will discuss tomorrow, and you will have to be ready with the material. Especially when the Supreme Court was delivering the judgments between 1965 and 78, it was criticized that the Supreme Court was in politics. Recently, there is another book, Growing Intolerance to all these things. When we were students, it is not in IC Golak, rather Keshavananda Bharati versus State of Kerala, AR 1973 Supreme Court, page number 1461, that basic structure has come. It was raised by Madholkar in Sajjan Singh's case. Attorney General K.K. Govendagopal's father, he was Nambiyar, he has raised that one in IC Golaknath case, and the court said there is a force in this argument, but that is not required now. It was not a sudden development, my dear friends. How ADM Jabalpur case has come, how it was criticized. There were plenty of juristic books on controversial decisions. You may not be able to refer all of them, but you will have to tell them the gist. Even now, when we go to the class, we will tell about Granville Austin's book. What is that? Indian Constitution, Cornerstone of a Nation. Granville Austin's book. Okay. Some cases, when the Supreme Court was dealing with during pandemic period also, even online, the students were asking, what is this Suomoto case? How it is decided? My dear friends, in spite of having the curriculum differently, you may have your own things to rather update the students. The sixth step is evolve appropriate method of teaching. Here lies the difficulty. Even the best curriculum and most perfect syllabus, that is not possible with regard to Constitution. Even the best curriculum and most perfect syllabus remains dead unless quickened into life by the right methods of teaching, by the right kind of teacher. The biggest challenge is to choose appropriate method of teaching. Every presentation, every lesson will have its own peculiarities. You require different strategies. You require different tactics. These two are different. What is the method of teaching? When you are going for some monitoring bodies inspection, they will ask, have you adopted Socratic method of teaching or not? Do you know what is Socratic method of teaching? Nowhere in the world that is truly adopted. It requires a lot of time. I will only give you brief idea about one or two things. Socratic method, lecture method, case study method, problem solving method, observation method, conversational method, assignment method, clinical method. There are 150 methods of teaching, including hybrid methods of teaching. Law teachers, sir, we are very comfortable with regard to lecture method, but sometimes we will also adopt other types of methods in combination with this one. What is this Socratic method? It is rather attributed to Socrates. It is a cooperative, argumentative dialogue. They start with hypothesis. Somebody will counter it. Hypothesis is not a conclusive proof. Somebody will contradict it, and there will be argument and fighting. Ultimately, even without reaching an answer, they may go away. Is that the method that we are adopting? It is also pedagogical technique, they say. A teaching style, a form of cooperative, argumentative dialogue. We had argumentative dialogue, my dear friends. I told you a number of issues when myself and Vijay Kumar and Professor Mallar, we were going for cooperative teaching. But that is quite different. We know in advance certain things. We develop our argument based upon that. The entire classroom is divided. Heated exchanges were there. But that is not true to Socratic method. In America also, my dear friends, they have adopted modern variant of Socratic method. More Socratic method is coupled with case study method. What will happen when they adopt it in case study method? In advance, case is given, argue it in the classroom. Law students are required to prepare at home, like flipped classroom, and summarize it and come for the class prepared. But the problem here is that there is what is known as cold call. Among all the students, teacher will show one person. He feels that he is superior sometimes, or he may feel insulted also. So there is a basic discriminatory or intimidation, fear or stress created in this particular method. So, of course, one has to say that Socratic method coupled with case study method is considered to be a successful one. Issues relating to poverty, unemployment, or labor problems, all these things can be meaningfully discussed in order to arrive at a conclusion or reasonable decision. My dear friends, whatever may be the method you adopt, if individual study takes 1 hour to learn, group discussion takes only 45 minutes to learn, and class discussion takes only half an hour to learn, my dear friends. So always give scope in the classroom for discussion. There is for new teachers, there is what is known as micro teaching. It is developed during 60s at Stanford University by Dwight Allen. This is a method. In capsule of 10 minutes, a person will present his teaching. It will be assessed by peer team and improvements, suggestions will be made. Now, peer team and all these things are not possible. At home itself, you can record and see what are the deficiencies we have. This is considered to be a very good exercise for the teachers at the first step of their ladder for teaching profession. There is flipped classroom. Flexible, flipped. F stands for flexible environment, learning culture, and I stands for intentional content, and then professional endeavor, educator. This flipped classroom, learning will be at home. They will give the material, come back and argue in the class. This is considered to be a wonderful exercise, and flipped classrooms are considered to be successful even though we have not adopted it so far here. Challenges in the classroom. I will give you 1 or 2 challenges, my dear friends. When you are teaching, suppose you are teaching Article 15. What is class 1? State shall not discriminate against any citizen on grounds of only religion, race, caste, sex, place of birth, or any of them. In order to facilitate, some groups have Article 15 class 4 First Amendment, it was added. 15 class 3 was there. Nothing in this article shall prevent the state from making any provision for women and children. So in class 1, they have prohibited discrimination based upon sex. So special provision for women is an exception justified. Age is not a prohibited ground. Why children are mentioned under 15 class 3? What answer we can give? We would give answer saying that to show the concern of Constituent Assembly members to protect the children. But why should they mention about children in 15 class 3? My dear friends, look into the provisions relating to trade, commerce and intercourse. 301 to 307. These provisions, they require a lot of time, so I am not rather giving you the total comment on this. Definitely suffers from defective drafting. These are all the things which we have faced. Sometimes students may not ask, but we have faced. Similarly, the latest cases with which we were discussing previously, all these things are also possible challenges in the classroom. Errors in drafting constitutional provisions, how they are affected. Relevancy of the problem, next one. After our discussion was over on presidential system, nearly it took 3 hours for us. Next day, one student asked, "Sir, is it important for us to practice?" What is the relevancy of the problem you are discussing? They do not see real connection between actual practice and some of the provisions of the Constitution when we explain. Similarly, when tribunals and all these things, CIT is established, what is the relevancy of discussion of service matters? 309, 310, 311. In some of the universities, it is surprising to note that these provisions are not there in the syllabus. My dear friends, 311 is required. It is one of the things wherein constitutional guarantees were given to the civil servants and principles of natural justice were recognized. Another article under Article 22 also, principles of natural justice are directly recognized. And then the challenges can be illustrated and met through moot court problems or mock trials. Mock trial is not relevant for us, but moot court. Different constitutional issues will have different approaches for discussion. Students will be always asking whether you are in class 1 or when you are in LLM or LLB, "Sir, will you give us notes?" Of course, teachers like me can escape by saying that nobody can understand my handwriting. First Brahma, next Mahatma Gandhi, afterwards myself. Nobody will be able to understand my handwriting. So don't ask me the notes. But nowadays, because of computer, so why can't you send a PDF file directly? They are asking. Not possible for everything. Certain important latest developments can be given. Step 8, use of ICT, information and communication technology. You even in your teaching learning aspects of accreditation, NAC, they say whether you have adopted ICT or not. In classroom learning, it can be associated, especially when you go for synchronous and asynchronous learning. You can say directly this ICT method is used in running our faculty development programs, and also our student development things are there. So we have adopted that value added courses. It may be noted, it is not there for other disciplines. What we have is CALR. CALR, Computer Assisted Legal Research. Computer Assisted Legal Research is there for us. This has become a separate discipline itself in several foreign universities, my dear friends, wherein the skills of rather tapping the internet sources were given, not chat GPT. This also can be traced if the person copies one of the essays we have given. In the footnote, he has given chat GPT. What we can do then now? It has become a reality. And language also, it adopts the same language which you use. So there are necessary safeguards to find it out. But what I am saying is that how this CALR is useful. Electronic database is there. Large bodies of case law are available online. Additional benefits are there. You need not rather search for hours together or months together as we were doing when we were doing PhD. That is not necessary for you. However, some jurists like Robert Berring and Koch, they have viewed that CALR is bringing about profound changes in legal community. There is no doubt, but we are also having the disadvantages. Number one, affordability is a problem. Affordability, accessibility, acceptability, and training of these things is a problem. When large number of ill-equipped and ill-equipped law schools are there, how do you adopt CALR? And it is basically unequal. Technical problems are there. We have seen during COVID period when we were taking our classes online. And then, except for referring the cases and other important material, it cannot substitute classroom interaction. In the classroom, live they are seeing the actioneering of the teacher. The influence of the teacher will go on forever. That is not possible. It cannot substitute personal contact of the teachers. Problems of, as I have told you, chat GPT and other things, there are other aspects of it. Now, step 10, the last one, instructional design. whether you show it to others or not, those who are having rather little experience, just started their career in teaching, must necessarily undertake this exercise. It is a blueprint of teaching. It is a blueprint of teaching, my dear friends. How do you go about it? It is a logical one, or that take rough paper only. Every day when you are preparing, just write down, this is my instructional plan for effective presentation of the subject matter. The advantage of it is that it minimizes deviation. It minimizes deviation. The general complaint against us is that, against old people, what about mighty? It minimizes deviation. Sorry, I won't take tea or coffee. I'm a very good boy. Okay. Once you evolve appropriate method of teaching and start thinking about thinking, then it brings confidence to you. It promotes refinement of teaching. Even now, my dear friends, we may pretend that we know everything, we do not know much. Before going to the class, we just prepare. At home also we will see what is that we are going to teach. As I have told you, once you adopt this instructional plan, you upgrade, update, and enrich the knowledge. And then when you use this instructional plan, it economizes the time. Deviations, as I have told you, will be less. We deviate much. That is one of the criticisms against us. Learners' difficulties can be anticipated. So when these are the advantages, why can't we adopt instructional plan? What are the rudiments of instructional plan? Number one, go for what is that you are teaching. Topic of teaching. Title, whatever you may call. Just write the title. It takes not more than 1 page, my dear friends. And then type of the class. Is it LLM or LLB? Whether they are in the first semester, second semester, like that. What is the time available? 1 hour is given. The teacher, after taking attendance, the previous class teacher comes. 5 minutes over. You go there. They stand. Attention. That is only attention, not motivation. Then you start. Then in the last class, like that, you say. So the actual content will be less. Type of the class, time available. Always estimate previous knowledge. My teacher always used to start. In the last class, we were discussing about this one. Aurangabad's Vice Chancellor is there, na K.V.S. Murthy, K.V.S. Sharma, his father, K.S.N. Murthy. Always he starts with that. In the last class, we were discussing about so and so, so and so. So previous knowledge is estimated. In this class, we will be discussing this one, objectives, 5th one. Why you are discussing this topic? Teaching aids. We suffer from chalk and talk syndrome. Our teaching aid is that. But go for at least here some PowerPoint so that you can save time. You need not write on the board. Then Always I tell you, my dear friends, it should be smooth takeoff and safe landing. Teaching should be smooth takeoff and safe landing. So start with a sort of introduction. And then you tell them the content, presentation, highlight the teaching points, and treatment. Treatment, I have told you, your strategy, your method, and all these things. Every class has value orientation. At the end, don't end the class abruptly. Sum up what you have covered. And then put one or two questions here and there. That is evaluation. These are the 9 steps. Theme or the topic. That is first one. Second one is the type of the class. Third one is time available. Fourth one is previous knowledge. Fifth one is objectives or purposes. Sixth one is teaching aids. Seventh one is instructional procedure starting from introduction to value orientation, which I have told you. Eighth one is summing up, and ninth one is evaluating. Now, if you do all these things, my dear friends, the first formula which I have told you, terminal behavior minus entry behavior, is the benefit accrued you will be able to achieve. You need not show it to anybody. Nobody will be there to check you. But at the same time, it is highly advantageous, my dear friends. I have experimented on various teachers. When students come to me and tell, so-and-so is not teaching well, you change the teacher. The same person, after 1 year, the students came and asked us, sir, please allot another subject to him. These are the harsh realities, my dear friends. While doing so, you can keep in your mind, grade the subject matter. Must know things will be there. What you must know, should know. And what are the things which are nice to know? Which I was telling you, like father of K.K. Venugopal was an MBR. He first writes in IC Gorkana. It is only nice to know, not that essential. Develop the subject matter which you have taken up. Proceed from known to unknown. I have told you, smooth takeoff. So, if it is known things, there will be smooth takeoff. And then develop the subject matter like that. From known to unknown, simple to complex. In the middle, you will have to check whether the students are properly motivated or attentive. Deliberately, you can put one question or crack a joke against one student like that, so that everybody will be, you come back to the classroom situation. Mind it, even if you are a great orator, for every 15 minutes, there will be a switch off among the students. You will have to bring them back. So, how do you bring them back? Check their level of understanding in the middle. If you follow your lesson plan, these difficulties will not arise. Keep time track always. Recapitulate and revive. These are the things, my dear friends. Hopefully, I have given you sufficiently